Okay, so thank you for joining us to learn about charitable giving and how it can benefit you in the state, and for those foundations that you would like to help um, in the future. We have with us today AngelaTylock. She's an associate attorney with the Meier Law Firm, and she's offered to educate us on charitable giving. And so thank you, Angela, for taking time to speak with us today.
Thank you. And thank you, Susan, for having me. I appreciate the opportunity to be able to spread some of the knowledge I have to a very important charitable organization in our area doing some really fantastic work. So thank you for having me. So as Susan mentioned, I'm an attorney with Meier Law Firm. We're an all-women firm located in Latham, New York. Our primary practice areas are estate planning, estate administration, guardianships, business law, and real estate. So that's our primary focus. We're really focused on making sure that people are planning for their future and what that future might look like. Okay, so just a quick agenda for the day. So I am going to talk about 4 main topics throughout my presentation today. Those topics include what is charitable giving, ways to include charitable giving in an estate plan, important, also gifting during lifetime, so some tax benefits that you'd want to consider, and then some basic tax considerations, and then I've allotted time at the end for some questions. As always, if you have questions throughout the presentation today, feel free to put them in the chat. Susan can ask them out loud, or at the very end, we can also have time for questions. So throughout the time today, if you have questions, don't be afraid to ask them during the presentation. So as a brief overview, what is charitable giving? So charitable giving is the gifting of cash, property to a charitable organization. Gifting can also include stocks or bonds. It does not have to be liquidated assets in order to make a gift to an organization. It can occur through the creation of a trust, either during your lifetime or in your will. And it can also be accomplished by naming the charitable organization as a beneficiary on your financial accounts. So that is an option that many people don't know about, but it is something that can be done. And also endowment funds can be created. Oh, sorry about that. I don't know why that jumped to the very end. Just a little preview. Okay, sorry, I'm not sure why that happened. Okay, so ways to include charitable gifting in your estate plan. Charitable gifting can be included in various different ways in your estate plan. I'll go over them briefly here and then go into a little bit more detail about the different options that are available. So different ways to include gifting in your estate plan: through your last will and testament, through beneficiary designations on your accounts, through inter vivos or testamentary trusts, gifts during your lifetime, or an endowed fund. So for your last will and testament, this is a document created by you for the sole purpose of determining how your assets are distributed upon your death. It controls only the assets that don't have beneficiaries on them. So that's sort of a common misconception in estate planning. Your will only controls things that don't have beneficiaries. So if you have retirement accounts that have beneficiaries, or bank accounts that have a transfer on death designation, those accounts will not be controlled by your will. So again, kind of common misconception that's out there in estate planning. Additionally, a will can be changed during your lifetime, so long as you have capacity to change those documents. Additionally, your will does not control jointly owned assets. So for example, if you purchase a home as a married couple, it would go to your surviving spouse, or a joint bank account with your children or spouse would go to that surviving owner, not to your will. So again, joint assets or assets that have beneficiaries on them are not going to be controlled by your will. common myth. If you don't have any will, the government will get your money. So not exactly true. Although the government does appear on this list at the very, 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 very end, they're the last resort for inheritance of your estate. So without a will, the state will distribute your assets among your heirs according to the law that's in place. So for example, could be your spouse, your children, parents, siblings, nieces or nephews, aunts or uncles. Every individual is different, and your goals for lifetime and post-death are unique to you. So really important to have your documents in place. If you don't, it may not be distributed based on your wishes. It would be distributed based on the state law. It could result in added expenses, as someone may need to go to court to be appointed in your estate. And that process can be a little bit more complicated if you don't have a will in place. So your will allows you to plan ahead and ensure your wishes are followed. Beneficiary designations. So beneficiary designations are hugely important. A lot of people throughout life's transitions, life's journeys, forget to update their beneficiaries on their documents. However, it's incredibly important because you can include beneficiaries on various accounts: stocks, bonds, investment accounts, retirement accounts, your standard bank account at Trustco or Boston Spa National. Those can include beneficiaries on them. Your life insurance policy, all of those accounts can have a designation of a beneficiary or be payable on death or transfer on death. So when I say payable on death or transferable on death, some banks call it a different thing. So really what they mean is a beneficiary designation. They just use a different term based on their policies. Upon your passing, those accounts are transferred to the named individual or to the charity or charities that you choose without the need for probate of your will. So changes to your beneficiaries can impact the rest of your estate plan as well as tax planning for the future. So if you are making changes, you should always consult with an attorney and a tax professional just to make sure that you're still in line with meeting any tax requirements that may come up for your particular estate. Always a bonus here, for accounts with beneficiary designations, it's possible to name both family and a charity. So you don't have to pick one or the other. You can benefit whomever you want to benefit, which can include both family and charities, if it's your intention to provide for both. So leaving a portion of your account doesn't mean you have to disinherit your family in order to do so. So my favorite question, what controls a will or beneficiary designation? I gave you a little sneak peek of this before. Your beneficiary designation is going to control. So if it's different from how you've named things in your will, if your designation is different from what you think is going to happen through your will, the beneficiary designation will control. So you may have left assets in your will to a particular charity, particular organization, thinking that they will benefit from that designation, but you've already got your beneficiaries listed. So there wouldn't be any assets in the estate to benefit that charity. So always bearing in mind, the beneficiary designations will control over a will. Everybody wants a trust. That's what I hear most common in estate planning. I want a trust. So there's a lot of different kinds of trusts that are available to you. It may not be right for you, and it may be right for you. It really depends on your very specific circumstances. Always important to talk with an estate planning attorney about that process. What kind of trust might be right, not only for your estate planning wishes, but also for your tax planning wishes. So a lot of benefits depending on what kind of trust you're looking at. So always want to take that into consideration. So an inter vivos trust is a trust that's created during your lifetime that has assets transferred into it during your lifetime. Okay, so it's created and funded during your lifetime. This trust can be revocable or irrevocable. It can be, if it's revocable, that means it can be changed or revoked during your lifetime. If it's irrevocable, that means only some terms can be changed and it cannot always be revoked during your lifetime. So always bearing in mind your specific circumstances will decide whether revocable or irrevocable trust will be the best path for you. Trusts allow you to choose the beneficiaries who will be entitled to the income during your lifetime and who inherits it after you pass. So one trust in particular would be the charitable remainder trust. That's a type of trust that allows you to name charity as a beneficiary of the trust after a period of time. So for example, you could benefit a family member or friend for a period of time during their life, and upon their passing, the remainder could go to a charity. So that would be one example of how to make sure you're fulfilling your charitable wishes and also making sure you're benefiting your family if that's your goal as well. A testamentary trust is created post-death through your will. So it's created in your will. It gets funded upon your passing. It allows you again to set those specific terms, who will inherit, how they inherit, and when they'll inherit. So can be customized to fit your specific needs. Again, trusts don't make sense for everyone. So it's really important to talk to an estate planning attorney to make sure that a trust is right for you in your specific circumstances. A trust can be an important estate planning tool, specifically when we're talking about long-term care, including qualifying for Medicaid or other government benefits. It can also be helpful in planning for the disability of a spouse or loved one who you'd like to provide for during your life or post-death. Okay. If properly drafted and funded, a trust can help reduce or eliminate your probatable estate, which is a really fancy term for saying it could reduce the taxes that happen on your estate upon your passing. So reducing the amount that's in your estate upon your passing has tax benefits that may be available to you. And then you can designate a beneficiary to inherit after the lifetime of a loved one. So again, it could benefit a spouse or children during their lifetime. Upon their passing, remainder could go to a charity. So again, don't have to choose between one or the other. Really, your estate plan can be customized to make sure whoever you want to benefit will benefit from those documents. So gifting during lifetime. So during lifetime, gifting can be done through cash, check, credit card directly to an organization. And lifetime gifts are often used for tax and estate planning purposes, specifically with long-term care, for example, talking about planning in order to help qualify for certain long-term care benefits. Doing estate planning and tax planning can help provide for those benefits. Gifting during lifetime can also include gifts made outright or through trusts, annuities, or endowed funds. You can also give stocks during your lifetime. So by giving stocks during your life, you might eliminate or at least lower the capital gains owed on the stock. The benefit, if any, really only occurs if you donate the stock prior to selling it. So that's a huge benefit. If you own stock, you can transfer the stock outright to the organization. When they sell that stock, they don't have to pay the same tax on it. So that's a benefit that's provided, and also a trick for planning if you have a lot of stock in your estate. So an endowment fund. An endowment is typically organized as a trust. It allows the organization to use the income generated for specific charitable purposes, but keep the principal fully untouched. So often it's invested with an advisor to help make that money grow during the lifetime of the charity, and then the income that's produced by that is used for charitable purposes. So it's really thinking about long-term legacy gifting that will provide a continued benefit throughout the lifetime of the charity. Most have a certain maximum amount that can be withdrawn in 1 year. So for example, if it's a very well-invested endowment fund, it could produce a significant amount of income. There's a certain limit that can be withdrawn every year. However, that would be done with a specific financial advisor. They'd let you know exactly what amount can be withdrawn based on that particular endowment fund. An annuity is an insurance contract that pays out invested funds over your lifetime. They can be set at fixed or variable investment structures. So depending on the structure, it could impact the amounts that are paid out during life and death. There are both taxable and non-taxable annuities that exist. It provides some level of income to the policy owner during lifetime. And then often there's a death benefit rider that's attached that allows some level of death benefit to be paid out upon your passing. It can have named beneficiaries, again, including charitable organizations. So again, huge benefit that could provide income to someone during their lifetime, and then again, have that remainder that's passed on post-death to a charitable organization. Oh, sorry, did it again. Okay. The durable power of attorney. So the durable power of attorney is an incredibly important document. I am a firm believer everyone over the age of 18 should have this document in place. Really, it's planning for the unknown. So the power of attorney document allows you to choose a person to manage your finances during your lifetime in the event you're not able to manage them for yourself. So this can come into play in various circumstances. For example, it could come into play, you're having surgery, you're going to be laid up for a period of time, you need someone to step in and help make some decisions for you. It just so happens to be around that time of year where you tend to give gifts to charitable organizations. Your agent would be able to step in and do those things for you. So it allows someone to help manage your finances during your lifetime. The power of attorney document can include powers to allow someone to do estate planning, tax planning, long-term care. All of those can potentially lead to charitable giving during your lifetime, especially if you are someone who tends to give gifts during your lifetime. That allows your agent to continue in that same gifting pattern. So it's making sure that your wishes are continued to be followed. It puts someone in that position to be able to do that. Your power of attorney also, it is incredibly important that it's properly drafted to include specific gifting language. So the one that's available online that you can print out doesn't always have specific gifting language included in it, which can lead to the inability to make gifts. So always consulting with someone who might be able to help make sure that that's proper. If your agent has the ability to make gifts by adding specific gifting language, they're also permitted to make gifts to charitable organizations that you've chosen to benefit. So again, really important that it's properly drafted, which leads me to my next topic of DIY estate planning. So I'm hearing more and more about, I could just print my will offline, it'll be fine. There's free wills opportunities online, which can be great. They can be. However, when it comes to charitable giving, DIY wills are not the best option. And I highlight that in a world of DIY, there are a few documents which you should not DIY. Your estate planning documents shouldn't be created through DIY websites. And although they may advertise as low cost or no cost estate plans, those websites cannot ensure that those provisions are consistent with the law. They have no way to do that. They also can't ensure that your documents are properly executed. And so we're running into more and more circumstances where a document was created DIY style, and it's now not being held as valid in courts. And so what happens is those documents get thrown out. And it goes by the law, it goes by intestacy. So that list I mentioned earlier, parents, spouse, children, cousins, that list is who is inheriting rather than the people who are listed in these DIY wills. So they cannot ensure that the charity you're benefiting is properly named, that the gifting language is correct for that specific charity's use and benefit. And it's especially true if you're including a charitable gift. Consulting with a legal professional helps ensure that those documents reflect your wishes and that your contributions are properly accounted for. Additionally, as I mentioned, we're seeing more and more DIY wills that are coming through. And although they're advertised as free or low cost, they actually tend to be more costly to probate. Because they're deficient or they contain invalid provisions, they're actually leading to more and more costs on the estate side of things rather than the planning side. And so really it's just shifting it to shifting those costs to a later portion. If the will is thrown out, the charity you're hoping to benefit may not end up with anything if your will is deemed invalid. So incredibly important, especially when you're leaving to a charity, that they're properly drafted. DIY wills also don't take into consideration special estate planning terms and documents that may be necessary specifically for disabled beneficiaries, blended families, second marriages, or minor children. This is especially coming into play with disabled beneficiaries. We're seeing a lot more DIY wills thrown out, and someone who has a disabled child or a disabled adult child is inheriting, and it's having impacts for their benefits that they're receiving. So incredibly important to pay attention and make sure that those provisions are properly drafted so that the will is not thrown out. So tax considerations. As full disclosure, we do not provide tax or accounting advice. We are not tax attorneys. So the tax information that I'm providing is really for informational purposes only. It's not intended to provide, nor should it be relied on as tax or accounting advice. Again, I'm not a tax attorney. You should definitely consult your tax or accounting advisor before engaging in any transaction or making any major gift. Especially to charitable organizations. There's a lot of really great tax benefits that are out there for giving to charitable organizations. It's incredibly important that you are taking advantage of those when you're making those gifts. So if you make a gift to a charitable organization during your lifetime, you may be able to receive a tax deduction for that lifetime gift. You should check directly with that organization to determine what portion is deductible. Most charitable giving arms of the organizations know what portion is going to be deductible for their donors. Your deduction is dependent on your adjusted gross income. And before you make a major donation to a charity, you should check with a tax professional to determine how much you'll be able to deduct on your personal taxes, because again, it is entirely dependent on how much what your adjusted gross income looks like individually. So it's important to make sure that you're accounting for what you specifically are able to deduct. If you leave money to a charity at your passing, there are additional tax benefits leaving assets directly to a charity. So for example, this can be accomplished by naming a charity as your beneficiary, which might reduce your taxable estate upon your passing. Additionally, tax-exempt charities have additional tax benefits and may not be required to pay taxes on certain investment or retirement accounts if they're named as a beneficiary on those accounts. Whereas individuals, if they're named as beneficiaries, they would have tax liability that may come with inheriting those types of accounts. So now specifically to the Epilepsy Foundation of Northeastern New York, gifting to the Epilepsy Foundation of Northeastern New York can be done by any of the previously mentioned methods. There are also specific purposes that we'll get into a little bit further here as well. So when giving to the Epilepsy Foundation of Northeastern New York or to any charity, there's always the option to give for a specific use or to leave at the terms of the discretion of the organization or charity. By leaving it to the discretion of the organization, the foundation is permitted to meet the ongoing needs of the population that they're serving. So it can be helpful to leave it more in a general gift so that the organization can decide how that would best fit in with their current needs. As I mentioned, gifts can be made for specific purposes, both during lifetime and post-death. So for example, there's a few specific purposes here that I've listed specific to the Epilepsy Foundation of Northeastern New York. So the Care, Cure, and Awareness Fund, the Epilepsy Care, Cure, and Awareness donations support education, advocacy, research, and support for programs that care for people living with epilepsy in the community. They also support research towards a cure for individuals living with intraceable seizures that cannot be controlled by the medications, devices, and surgeries that are available today. And finally, it helps spread awareness to the community and the thousands of individuals who have yet to find the Epilepsy Foundation of Northeastern New York. Additionally, cars. So you can donate a used car, and a portion of the proceeds will go back to the Epilepsy Foundation of Northeastern New York. There's more information available on the specific website about how that process is run. And also, if you have any questions, you can always contact Susan directly. She'll point you in the right direction for those. There's also the Send a Child to Camp campaign. Those proceeds go directly to sending a child with epilepsy in one of the 22 counties to a summer camp of their choice. So a great program there that funds can be directly given to. And then Clink. So Clink, you can recycle your bottles, cans, and donate the proceeds to the foundation. Again, always recommend going to the website of the organization directly for more information about how those programs are run and how you can get the proceeds directly to that organization. And then finally, the Purple Legacy Foundation, or I'm sorry, the Purple Legacy Society. So the Purple Legacy Society honors individuals who have named the Epilepsy Foundation of Northeastern New York in their wills or estate plans. So I have more on that. So the Purple Legacy Society can accept, the foundation, the Epilepsy Foundation of Northeastern New York, can also accept stocks or other investment accounts or a portion of them. It can be left to multiple beneficiaries, both family and charities. It doesn't have to be all or nothing. So for example, you could leave a percentage to family, a percentage to the charity, or a specific dollar amount, either way. If you leave a gift of stock or make a gift of stock during your lifetime, consider transferring the stock directly rather than selling and giving the proceeds. It would likely protect you from tax liability with regard to those stocks. Again, as always, consulting with a tax professional if you're planning to make those types of gifts. One too far. There we go. So the Epilepsy Foundation of Northeastern New York, as I've mentioned, can be added as a beneficiary on any account. Doing this, you'll become part of the Purple Legacy Society. The Purple Legacy Society was created to recognize, honor, and thank individuals who make a legacy gift through their estate plan or a beneficiary designation. The honor can be bestowed either during lifetime or post-death. So if you make a legacy gift in your estate plan or designation to the Epilepsy Foundation of Northeastern New York as a beneficiary, let the Epilepsy Foundation of Northeastern New York know during your lifetime, and you'll be added to this special society. During your life, you can also donate your required minimum distribution from your IRA or a portion of it. Again, it doesn't have to be all or nothing with any of these options. You can always donate a portion if you're so inclined to benefit a charitable organization and family. To do that, you should speak directly with your financial advisor and tax advisor. And I always recommend also talking with the organization that you're planning to do that with, just making sure that they're aware that that is occurring. So especially in this case with the Purple Legacy Society, letting them know specifically that you're making this gift during your lifetime, it'll help let the foundation know. And then questions. I know we're a small but mighty here, so if anyone has any questions, please let me know. I'm happy to answer anything that might have come up. And if not, that's okay too. So, oh, I saw Jerry, I saw you unmute. Did you have a question?
I don't have a question, but I just want to thank you for the presentation. It was very informative and helpful.
Thank you. I appreciate it.
Yes, it was very thorough, so thank you.
Thank you. And if there are any questions, if anyone has questions that come up, please feel free to reach out to me anytime. I'm always happy to answer questions. If I don't have an answer to your question, I can always point you in the direction of the Epilepsy Foundation, specifically to Susan, to be able to provide you with that answer as well. And I don't, my left side is frozen, it seems.
I'd like to ask a question.
Yes.
Hi, Angela, Stephanie. In regards to stocks, so if somebody gifted stocks to a charity, does that mean like it could potentially fund for the like lifetime of the charity, where it would actually like prevent them from having to rely on current donations? I don't know. I was just thinking like, because that's kind of a great way to keep charities like for, you know, providing their services. Is that what happens when people gift stocks?
Yeah, so when you make a donation of stock, for example, you would be able to transfer that stock directly to that organization. They could maintain that stock for a period of time, receiving the income from it to use for charitable purposes or reinvesting it. As that stock continues to grow, they would be able to sell it at a point whenever it makes the most sense for the organization. And they're exempt from capital gains tax. So there wouldn't be the same capital gains tax that we as individuals pay when a stock grows massively. So the organization, yes, could use the funds over the course of their I don't want to say lifetime, over the course of their continued operations.
Right, yeah.
Could use that to sustain whatever projects are going on with the organization. So yes, it could potentially, depending on the size of the stock that's donated, it could potentially increase to maintain through the lifetime of the organization.
Okay, great, thank you.
Angela, do you have any suggestions for just sort of getting the word out that you don't need to be wealthy to participate in charitable giving? Especially with small agencies like ours, gifts of any size are greatly appreciated, but I don't know that people always realize that.
Yeah, so that's a great question. It's always going to be just about continuously promoting that, and even saying that, you know, any size gift, $5, $10, it goes somewhere. It goes to helping with various aspects of the ongoing day-to-day operations of a charitable organization. So including that, I think even on your website is so incredibly important, because it does say, you know, we recognize that not everybody can make major gifts. And anything that you can give would be helpful. So I think including that language right on your website in promotional materials is also very helpful. I know you do a fantastic job specifically with putting out materials on a regular basis, especially about making donations, charitable giving, all of that. So putting that right in those materials also is very helpful as those materials continue to circulate in the community.
Thank you.
Those were great questions and helpful as we move forward with our program, because we did develop the Purple Legacy Society because we found people were putting our name in their estate plans, and we were receiving it after they passed, and we were unable to thank them for their support while they were living. So we wanted to have a plan in place so we can now thank them if they notify us that they choose to name the Epilepsy Foundation of Northeastern New York in their estate plans. So thank you.